Good afternoon, everyone, and good morning to those of you on the West Coast. This is Josh Willie, and on behalf of the Public Contracting Institute, I'd like to welcome you all to today's GovCon 101 session covering teaming agreements, joined by our expert instructor, David Gallacher. Before we jump in, just a few housekeeping announcements and reminders. For those of you seeking credit for the session, make sure you are tuned in till the end. There will be no passwords, but we will have a few polling questions. Your participation and engagement is important, so make sure you guys stay till the end to complete those polling questions. If you're seeking a certificate, you'll log into your PCI account and complete that quiz for that certificate as well. If you have any comments or questions, you're going to go ahead and submit that through that questions tab at the top right of your GoToWebinar window. That is that question mark. I do see a few hands raised. If you have any questions, please send that through the questions panel. You can find a copy of the materials under that paperclip icon as well. If you have any technical difficulties, please make sure to let me know. With that, I will hand it over to David.
Thank you so much, Joshua. I appreciate it. Yeah, just I guess two brief reminders on what she said there. One is the materials are available in the paperclip attachment thing, so you can download these slides if you want to keep a copy of it. The second thing is, as we're going through this today, if you have questions, type those into the questions panel, and we will get back with you as soon as we can. I might save them to the very end, but if they're topical and they're touching on something that we want to talk about, then we'll explore those, try to explore those in real time. But fundamentally, we're going to close out this GovCon 101 session as we normally do on GovCon 101s, and we're going to with a little bit of a Q&A, question and answer. So pay attention, because there will be a test at the end. So anyway, with that being said, your questions are welcome, and I hope my questions at the end are also welcome to you. But it's a pleasure to be here with you today for GovCon 101 to walk through this thing that we call teaming agreements. My name is David Gallacher. I'm a partner with the law firm Cutak Rock in Washington, D.C., where I specialize in all kinds of public contracts, most especially federal, but I also do a fair bit of state and local work as well. I do the litigation associated with some of these contracts, if there's claims, if there's bid protests, if there's investigations and such, but I also do a lot of client counseling relating to government contracting. Anything from the new raft of executive orders that maybe came out last week or the week before, to just how do we navigate all these FAR and DFARS provisions. I've been practicing for about 25 years, and at the risk of feeling a little important about myself, I think I've touched on just about everything. That doesn't mean I know everything. Oftentimes, I know enough to know that we need to dig deeper and ask additional questions. But I've touched just about anything in the FAR or DFARS at some way, shape, or form. For purposes of this here today, we're here to talk about teaming agreements here, and it's a pleasure to walk through this. I've set this up with 10 questions that I commonly get around teaming agreements. These are from clients. These are from when I teach this course, questions that often come up. I think it's helpful to kind of set the stage a little bit as to what teaming agreements are and what they are not. They are very common in the government contracting industry, and they can prove to be very useful, especially to build out relationships here. But I think we also need to be realistic as to what a teaming agreement can and will accomplish. So what I want to talk about here today over the next 75 minutes here is, first, when you're signing a teaming agreement, when you're negotiating a teaming agreement, what are your business objectives? What is it that you're trying to accomplish with this thing that is called a teaming agreement? Second, what are the roles and responsibilities? Who's going to do what under this teaming agreement, both now and also in the future when we eventually get this work? 3, how do my priorities differ if I'm the prime or the sub? In truth, you actually might have a different teaming agreement template if you're the prime contractor or if you're the subcontractor in the relationship, because oftentimes your priorities will differ, and we'll explore that a little bit. We'll talk about rights that the government has in my teaming agreements. We'll also explore the idea of the differences between a standard teaming agreement or a more traditional teaming agreement and a unique type of teaming relationship called a CTA, which is a unique term used under the GSA Multiple Award Schedule program. CTA meaning contractor teaming arrangement. The GSA schedule program has their own little animal when it comes to teaming agreements. We'll then also talk a little bit about choice of law, and we'll walk through how Virginia treats teaming agreements, showing that really at the end of the day, at the risk of burying the lead here, the specifics that you put into your negotiated teaming agreement are really important to help guarantee what comes next. And in some respects, in many respects, courts often interpret a teaming agreement as an agreement to agree on some future subcontract in the future. But just because that's where a lot of the courts land, because that's the specific agreement that was negotiated, you might negotiate something a little bit different here. So we'll walk through choice of law and specifically look at how Virginia courts have handled these teaming agreement issues. We'll also talk about some data confidentiality issues that you want to make sure you're keeping in mind. We'll talk about some small business subcontracting issues that come up. In truth, teaming agreements are a great tool to help foster relationships with small businesses, whether it's a small business prime performing under a small business set aside and they need some large business subcontractor support, or maybe it's a large business that's performing under its small business subcontracting plan and wants to cement some of those relationships here. Teaming agreements often go hand in hand with with small business compliance issues, and I want to just make sure that you're aware of some of the issues to be careful on in that. We'll talk a little bit about exclusive versus non-exclusive, and then we'll close out by talking about what do I do if things go bad, and then we'll jump into our quiz. With that being said, though, let me start with this question here that should fundamentally inform all of your discussions whenever a teaming agreement comes up. What are your business objectives? What are you trying to accomplish with a teaming agreement? Historically, the requirements relating to teaming agreements were spelled out in FAR 9.6, FAR subpart 9.6, that spelled out what teaming agreements are, what they're not, and what the government would recognize what the government's rights were. As part of the revolutionary FAR overhaul that's been going on since last spring, those requirements have been pulled out of the FAR and they have been moved into the new FAR companion. And here's a QR code if you'd like to click on it or scan it. It will take you over to the FAR companion. And the FAR companion is designed to be a, companion to the FAR that includes more process or policy-based requirements, as opposed to, strictly speaking, one of the objectives of the RFO is to try to make sure that the FAR includes really only statutory requirements that have to happen. Teaming agreements are a tool that are beneficial commonly for the government, but they don't have to happen. And so in that respect, they are in the process of being removed from FAR 9.6 and moved over to the FAR companion here. And there you go. Now, the good news on this is the requirements have not really substantively changed, meaning it's not like they reworked it and you now have the FAR companion requirements relating to teaming agreements are fundamentally different. They are fundamentally still the same. The phrasing has changed a little bit here, but I've got the updated language here. So first of all, what is a teaming agreement supposed to try to accomplish? And the answer is it should, according to FAR, the FAR companion 9.000, two companies provide complementary capabilities, and they also are offering the best combination of performance, cost, and delivery. So fundamentally, that is what your teaming agreement should be able or should be trying to accomplish here. And oftentimes I see this kind of spelled out in the whereas clauses and the recitals at the beginning of it that explain that this is the purpose of it. We, vendor A, vendor B, company A, you and me, we have complementary capabilities. We intend to work together to make sure that we are offering the government the best combination of performance, cost, and delivery. So all of that comes into play there, that fundamentally these are the kind of the DNA of what a teaming agreement is supposed to be. If a teaming agreement is not going to provide the government with the best combination of performance, cost, and delivery, you might want to rethink the relationship. Again, at the end of the day, a teaming agreement is fundamentally a relationship builder. It's a strategic document saying we're going to work together to maybe chase business, to do some R&D. It could do lots of different things here, but the key objective of this is that it should be delivering a better value to the government at the end of the day. And if it does deliver on that value, then the FAR companion here specifically states that, well, that the government will generally recognize these and allow them to be used to, again, deliver on that value proposition. Now, you should fundamentally customize your teaming agreement. Every teaming agreement is unique. There is no standard form that you have to use. I think most companies work from a template that they have prepared. Maybe they found it online and you've modified it and you've included some of your own language. And I think that that's a fine place to start. But fundamentally, you want to make sure that you are negotiating every single teaming agreement. Don't sign anything that is a standard teaming agreement because somebody says, oh, I found this on the internet. I had a client once that sent me a teaming agreement, and they said, our teaming partner pushed this to us. They said it's their standard agreement. Should we sign it? And I said, what do you want to accomplish with this? Let's make sure that we are being thoughtful and careful on this, reflecting what we actually want to accomplish. And we redlined it, unsurprisingly, and we sent it back to the other side. The funny thing was at that point, they actually then had, well, quite a lot of red lines on their own original template, which told me they hadn't really reviewed it that much in the first place. So it's a good reminder, good thing to keep in mind here, that we can and probably should always be modifying the teaming agreement to accomplish your specific business objectives. Please never sign a standard teaming agreement. You always want to customize this. But with, like I said, working from a template, I think is a good idea because there's a lot of this that is fairly standard, but it's not exclusively. You want to, a lot of this is standard, but you want to make sure it's tailored for your specific business opportunity. All right, Joshua Lee, can you see me?
I can see you. Hey David, it looks like we lost you. Sorry everyone, it looks like he lost connection. We'll give him a moment to head back.
Joshua, you there? Can you hear me?
Yeah, I can hear you. You're back in.
Okay.
Just waiting for you to share your slides, David. Your mic is muted.
All right, Joshua, can you hear me now?
I can hear you now. You're muted again.
All right, can you hear me now, Joshua?
Yeah, I can.
Okay, my apologies to everybody on this. My browser suddenly dumped on me. So let me get the screen back up on this. I apologize profusely. All right, can you see those?
Not seeing them yet. Yep, I see them now.
You can see them now. Okay, wonderful. Thank you. Yep. Okay, so I've got several comments here. Lost connection. Yeah, sorry, everybody. Okay. Do what we can to get back on track here, and hopefully my internet doesn't hate me today. I apologize for that. Let me talk a little bit about roles and responsibilities here under a teaming agreement, because they can really vary from project to project depending on whatever you want. A contractor team arrangement typically contemplates one of two scenarios. One, two companies are coming together to form a joint venture. And it's two, the FAR companion specifically talks about it's two or more companies. So in truth, you could have 3, 4, 5 companies coming together to form some kind of a prime sub relationship or a joint venture relationship. I have never really seen more than 1 + 1 work. It strikes me that if you have multiple companies coming together, things are getting a little bit more complicated. I typically see companies do separate joint venture agreements in that particular scenario. But nonetheless, the FAR companion specifically contemplates that it can be 2 or more companies come together to form eventually a joint venture, or they come together to form some kind of a prime sub relationship. And that's what they intend to do, is they chase this federal business. Now we'll look in a minute here with CTAs, because CTAs are actually a little bit different in that, where they contemplate something that's a little bit like a prime sub. But in your teaming agreement, you should spell out what are the specific roles that we are playing. I'm going to act as the prime contractor as we pursue a particular opportunity. You're going to work as the subcontractor. That means I'm going to be putting in the proposal. That means I'm going to be interacting with the customer. It means I'm going to need your support in drafting the proposal. It means I'm going to need your support on some of the pricing information, so on and so forth. But the roles that we play are going to dictate some of the obligations that we ask from each other under our teaming agreement. So typically in these teaming agreements, there's kind of 2 flavors. I said there's the joint venture or the prime sub, but within the teaming agreement, there's 2 types of tasks that are commonly spelled out. And first, that is relating to what are we doing now with regard to proposal development or chasing the business. And then the second flavor is what are we going to be doing in the future once we land that work. Almost by necessity, that first set relating to the current work, the current proposal development work, is usually going to be fairly specific because we know what's expected. I'm going to be the prime. I need your people to come to my facility or to be available for video conferences. I need you to follow our directions, to make people available, so on and so forth, so that we can meet the proposal submission deadline. Oftentimes when we put together a teaming agreement, it's hard to know what that future scope of work will look like. We understand generally what the government's need is, but in truth, we don't necessarily know how that work share is going to break out. And so in that respect, the future work is often difficult to spell out, but not always impossible. I commonly see teaming agreements that spell out specific provisions that talk about, this is going to be the work share allocation. If prime contractor gets an award, then you're going to make an award, and it'll break out with this, with subcontractor performing these particular types of tasks, prime contractor performing these other types of tasks, and so on and so forth. Sometimes that's reflected in the body of the teaming agreement. I would say more often I see the body of the teaming agreement reference like Appendix A, that is the work share allocation. But fundamentally, if there is something that you are expecting from your teaming agreement and something that you are promising to do, that should be spelled out. Now, does that mean you're necessarily going to get the work share at the end of the day? Well, we'll get to that in a minute. Oftentimes, the answer is not necessarily. But I'll tell you, fundamentally, if there is something that you expect from your teaming partner, whether it's them putting up firewalls, protecting your data, making people available, et cetera, spell that out. Because if they break that promise, then you might have some remedy that they promised to do X and they didn't. In that respect, you might be able to get something out of your teaming agreement, even if it's not ultimately a guaranteed work share performance at the end of the day. Now, I mentioned prime versus sub here. I think that's the way most teaming agreements are formed up, with two companies working together, saying, I'm going to be the prime, you're going to be the sub. As I said, the FAR Companion specifically contemplates that you can also form a joint venture. But even in a joint venture, you usually have somebody that's a little bit up and a little bit down, whether it's a 51% owner versus a 49%. So functionally, there's oftentimes somebody that has a little bit of an upper hand on this. And if you're, and for purpose of this slide, I'm going to call that the prime contractor. The prime contractor's perspective a lot of times on these teaming agreements is generally pretty open-ended. Look, I want to keep control over this. Teaming partner, I want to work with you, okay? But at the end of the day, I want the flexibility to do what I think I need to do to get the business. I need the flexibility to make sure that I am keeping the customer happy. I'm more than willing to work with you, but I'm not going to make a promise right now that I'm not ready to follow through on, which is, for instance, that I promise I'm going to give you work. We still have a lot we're going to have to negotiate. We're going to have price. Gosh, there's the insurance and indemnification issues that always come up, right? We'll deal with that in time. Right now, let's just work with the task in front of us, which is the proposal development. A lot of times prime contractors say, look, I want to keep my options open. If there's a better option, a better price, a better technical solution that comes along from another teaming partner, I'd like the opportunity to break up our relationship so I can date that other company. Right? So some of those things are what's going to drive this. It is not necessarily that the prime is using the sub, but at the end of the day, the prime is more interested in keeping the customer happy than in keeping the subcontractor happy. And so a lot of times when I see these teaming agreements that are written by prime contractors, they've got a lot of mushy language in it that try to make sure we're chasing this business together and we're doing this in good faith. But at the end of the day, me satisfying the customer is going to be more important than me keeping you subcontractor happy. And I think from a prime contractor relationship, I get why you would possibly chase that. Now, if you're the sub, on the other hand, right, you probably say, like, look, I want to lock this down as much as possible. I don't want to give you the ability, prime contractor, to go out and start dating other companies and to replace me. I would really love to negotiate these things now, not later. I would like to be as specific as possible. Prime might say, oh, Dave, what are you doing? Subcontractor Dave Gallacher, we don't need to put all that stuff in. We'll deal with that when we get to it. And I say, yeah, I would like to make sure that we don't have a new thing to negotiate at some point in the future. Let's try to negotiate that right now. I would maybe want to insist, I want some face time with the customer, especially if they're not sure about what I can do, how I can perform. I would love to try to assuage those concerns instead of letting the prime contractor say, Well, I guess he's pretty good, right? Because they don't have a vested interest in my business as the subcontractor. Final point is a lot of times with the subcontractors, they say, look, we recognize there's still a lot up in the air as far as what the ultimate award might look like, but maybe there's a me and only me. Maybe there's an exclusive arrangement in here where if the government gets the, if the prime contractor gets the government award, then ultimately you're making a promise that I'm going to get that subcontract. So again, the priorities differ a little bit on this. And that's why, like I said, typically, I think most companies have two different templates that they will look at that set it up. If you're the prime, it's maybe going to be a little mushier. And if you're the sub, it's going to be a little bit more specific. Britt has a question that says, does the prime contractor take a different approach if the subcontractor is known to be the best and other prime contractors might want in? It's a great question, Britt, and the answer is often yes, right? Like I had a client once that did telecommunications services, and they were the only vendor that could cover over Antarctica, and that's where the National Science Foundation was needing some coverage because NSF runs the Antarctica research facilities. The prime contractor was very eager to lock in my client as much as possible. My client came to me and said, do we have to go exclusive with this company? I said, no, like you're the prettiest girl at the prom here. I think you could date around. You've got a lot of options on this. But in that situation, because of just how the business was set up, the prime contractor was very interested in being specific. I want to try to lock you up now to try to make sure that that opportunity is almost guaranteed later on down the line. So Britt, it's a great question because it's not always the case that the prime wants it to be mushy, but I would say more often than not, that's the way that these relationships typically play out. And let's see here, another one from Britt. Sorry, my computer's just so slow today. It says, do you see becoming great with IT subcontractors? And I'm not sure that I see it. I mean, the IT space is really so diversified that I'm not really sure that I see it. You have a lot of OEMs, like your Oracles, Microsofts that are usually in the supply chain. They don't normally prime when selling to the federal government. And I think they typically, so I'm not really sure that I see one option over another. But a lot of times with resellers, you have a lot of software IT resellers that have relationships with multiple companies. So I'm not sure that any one person has a lock on some of these markets. Let me see here. Anything else? Okay. Ursula says, she says, I've had primes that want to work on pricing the teaming agreement before negotiating the subcontract. What do you recommend? Well, the answer is it depends. It depends on what your specific business opportunity is here that you're chasing. If this is something that's really important to you as a subcontractor, you might want to stay ahead of that and say, let's try to lock this down as much as possible. A lot of times, though, the answer is, especially if you don't know the scope of work, it feels really risky to come through and give the prime contractor a specific price that we know they're going to hold you to, and then ultimately maybe come back and give you a scope of work that's 120% more than you expected. That might totally eat your margins. So I don't know, Ursula, that I've got a single perfect answer for you on that. Other than I think you want to try to leverage whatever advantages you have to get to exactly where you want to be. If you're a sub and you want to try to lock this down as soon as possible, I think staying ahead of that and trying to define that work share can be really helpful. But I also don't want companies getting too far out ahead of their skis and you're throwing out a number that at the end of the day may very well just be, a little bit of a fiction. All right, let me talk quickly about some of the government rights that the government has in teaming agreements. The FAR Companion specifically states that the government reserves the right to challenge teaming agreements, meaning the government will normally recognize teaming agreements, provided it's meeting the basic objectives that we talked about before, where you're complementing each other's abilities and where you're providing that value proposition to the government. But the government, nonetheless, the FAR Companion says that if a teaming agreement raises antitrust issues, then the government will not recognize that teaming agreement. The government reserves the right to pursue consent to subcontracting, notwithstanding the fact that you and I have entered into a teaming agreement where we nominally promise that I will give you the work. If at the end of the day, the government has the right to consent to that subcontract, the government has that right to consent to the subcontract, and yours and my promise might be overridden by the government's rights. The government reserves the right to make a responsibility determination. The fact that I like you doesn't change the fact that if my government customer doesn't like you, we might end up breaking up, right? And so you can't force the government to use a particular vendor that it doesn't want to use. Regarding data rights, a teaming agreement cannot limit what the government does with its own data rights. A teaming agreement does not necessarily limit the government's right to insist on competition in subcontracting, and also performance guarantees. A prime contractor cannot push down all the risk. The prime contractor is still ultimately responsible to the government customer for contract performance. Okay, question here from Hannah. If a subcontractor was included in your proposal, but the government, does the government still need to consent to the subcontractor? 44.2. It's a great question. FAR 44.2 typically applies to non-commercial contracts over the simplified acquisition threshold where the prime contractor does not have an approved purchasing system. If it's commercial, if you have an approved purchasing system, or if it's under the simplified acquisition threshold, then typically the government consent to subcontracts will not apply. And especially given the fact that the government is pushing more and more and more the idea that we are buying commercial, it certainly seems to indicate that the 44.2 consent to subcontract rights will probably apply less and less and less. So it's a good question, Hannah, because I think that most people, including the government, thinks that they have the right to consent to subcontracts more frequently than they do. And in truth, 44.2 applies in a much more limited scope. Non-commercial contracts where the prime contractor does not have an approved purchasing system and that prime contract is over the simplified acquisition threshold. That's where the right to consent to subcontracts applies. All right, Britt asks another question here, says, have you ever seen competing prime contractors entering teaming agreements with the same subcontractor? Yes, I have. I gave you the example earlier about the telecommunications services over Antarctica, and my client was pursued by multiple companies. The first one wanted to go exclusive. My client said no, and then they started getting other calls. So I know it maybe feels a little cheap, like maybe you're dating around, cheating on your partner. But at the end of the day, if that's where the business works out, I have seen that work out. Especially if you are a key supplier or a key vendor down in the supply chain where you're high demand. I commonly see that where companies are setting that up. I've got another example I'll share in a minute when we talk about competitive issues. Bill says, with current CMMC requirements, is the sub able to adopt the practice of the prime if on an existing project? And I don't know exactly. I guess it really has to do with the subcontractor's abilities, what their system looks like, what kind of data they have access to. If you have controlled unclassified information, then you're going to be CMMC level 2 or level 3. Period. And if you're not there, then under the new CMMC rules that went into effect in November 2025, You're going to be out. So this is really, in some respects, a discriminator for a lot of people in the DoD supply chain as to whether they are CMMC compliant or not. But sometimes you might be able to have a prime contractor that's holding CUI, meaning they need to be level 2 or level 3, and they're just managing the information that they share with the subcontractor, making sure that the subcontractor gets federal contract information, FCI, but not CUI. And if you're only getting FCI, then you only need to be CMMC level 1 certified, which means you can actually self-certify for that. It basically requires you to meet 15 basic requirements. So, to answer Bill's question, you don't necessarily automatically get to piggyback in. Each entity is going to be separately assessed. All right. Let's see here. Let me talk about CTAs briefly. Actually, I got another question here from Britt. Let's see in this. Will the government give special consideration to a prime contractor who's a small business despite having a subcontractor who is far larger? And the answer to that is it really depends on what the specific solicitation says. Obviously, if it's a small business set aside, then I think that that would be expected. And we'll look at some small business issues here in a minute. But kind of from a compliance standpoint on something like cybersecurity that I was just talking about, the answer is not really. The government has its requirements, and the prime contractor is going to have to meet them. And if you say I'm a sub, I'm not quite up to snuff, then they would probably say that, yeah, we're not sure you're going to be able to handle this award on that. So there's a little bit of consideration that is often baked into the solicitation, but not a lot of consideration. All right, let me talk briefly here about these CTAs that I mentioned earlier. CTAs stand for Contractor Team Arrangements, and these are a unique program to the GSA schedule, Multiple Award Schedule program. There's a QR code that you can scan that will take you to the GSA webpage that talks through what these are. But if you're a GSA Multiple Award Schedule vendor, this kind of traditional prime sub relationship that I just described doesn't sound right to you. You're like, that's not really what our teaming agreements look like. We enter into these CTAs. A CTA is a little unique because you basically have multiple contract holders who come together and form a team to provide a solution to the government. Every member of a CTA must hold a schedule contract. So let's say there's 4 companies that come together here to pursue an opportunity through the GSA schedule program. 3 of you have a GSA schedule. 1 of us, me, does not. What that means is our team consists of 4 companies, but the CTA specifically consists only of you 3, and I am a subcontractor to that. Now, in truth, what often happens is within the team, one person kind of acts as the foreman or the lead, and they administer most of the work. But in truth, each of those contract holders has a direct contractual relationship with the government customer. And so technically, they're kind of all co-primes. Now, I don't have a GSA schedule contract, so I cannot be a member of that CTA. And I am necessarily going to be a subcontractor to one of those companies on that. But the companies that, even though they are maybe administered or assigned work down through the CTA lead, they are nonetheless kind of co-primes because they do have a direct contractual relationship with the government. Every member of the CTA must separately qualify for small business set-asides, and each member is required to comply with its own GSA schedule contract plus the terms of the orders issued under that particular CTA. Here's a chart that used to be up on the GSA schedule website. I think they've taken it down now, but it's good and helpful to show you what are some of the differences between CTAs and a more traditional prime sub relationship here. To identify this, and it's helpful just to distinguish between the two. But if you're in the GSA space, just keep in mind fundamentally that what you do is you come together, you form a team, And again, in order to be a member of the team, it could be anybody. But in order to be a member of the CTA, you have to have a GSA schedule contract. And so what you would do in response to a task order request or whatever that proposal looks like, you would identify the various team members, specifying these 3 that are members of the CTA, plus David Gallacher, Inc., not a schedule holder, but would nonetheless be part of part of our overall proposal. You identify the team leads, and then you identify what they'll be responsible for, and that might include responsibility for invoicing and payments, although I don't necessarily recommend that. GSA actually recommends you should probably have each individual CTA member submit their own invoices, and that's a little bit cleaner and faster. For somebody like me that's a member of the team but not a member of the CTA, well, I'm going to have to submit an invoice through my prime contractor in the more traditional way. List the multiple award schedule contract numbers, and you describe the relative tasks that each of us will perform, and then you set forth the pricing on this. Each vendor can use its own pricing. In the case, again, of subcontractor David Gallacher, where I don't have any contract pricing under my multiple award schedule because I don't have a contract like that, then I will typically be using the pricing for the prime contractor that is that's already on contract. Let's see here. New question. It says, David, can you please confirm from the previous slide that each CTA member must qualify under a set-aside? Did I hear that correctly? You did. So if there is a small business set-aside for say a service-disabled, veteran-owned small business, each member of the CTA team needs to qualify for that. Now, that doesn't necessarily mean that you can't pull out one of those guys. They're a large business. They're not going to qualify. Well, let's not have them be part of the team, but they're going to be part of they're not going to be part of the CTA, even though they maybe are still part of the overall solution, in which case we would make sure that we are managing and complying with the limitations on subcontracting and so forth. So, Ursula, you did hear me correctly. And again, it really it causes companies that they want to make sure that they're structuring these appropriately. All right, does choice of Hannah says, is there a reason CTAs only occur under GSA multiple award schedule programs? And I don't know that there is a particular reason other than this is what GSA has set up and structured to try to make sure that they are providing solution, whole business solutions there, as opposed to individual task orders from a service vendor and a hardware vendor and so on and so forth. It's just how GSA has developed it. I don't know that there's a legal reason as to why that's happened. All right, does choice of law matter? The answer is yes. Let me give you some examples here as to how teaming agreements are commonly interpreted. I once had somebody walk up to me and say, is a teaming agreement enforceable? And I said, yes. And the man was shocked. He took off his glasses and he was about to confront me. And I said, hang on here. It is enforceable as far as it is specific. And what that means is the specific obligations that you are promising in a teaming agreement may very well be enforceable if the relationship goes sideways and you end up in court. Generally speaking, courts interpret teaming agreements in one of two ways, and there's a little bit of a continuum here, but the two extremes are, one is viewed as an agreement to agree, and that is we're entering into a teaming agreement to pursue business together, but at the end of the day, we also recognize that there is a subcontract that will formalize this relationship. And so our teaming agreement might just be a stepping stone to agree to some kind of other formal document later on down the line. And when confronted with that, oftentimes courts will say, it's an agreement to agree. I'm not going to negotiate your future subcontract because that's not what courts do. The other side of this is whether a teaming agreement imposes an absolute duty to award a subcontract. And the answer is maybe. It depends on the specific terms. So let me give you a few examples here. First is a case out of Virginia, 1997, Schaefer Associates versus Cordon. It's an interesting case. It was going to be a records conversion process for the U.S. Air Force. They were going to be taking legacy microfiche and converting that into digital. Cordon was going to be the prime. Schaefer was going to be the sub. Schaefer was providing the digitizer. I love this. You know it's a 1990s case because they called it a digitizer, so it has a Star Trek sounding name. Anyway, the 1990s were awesome. Anyway, so that's what Schaefer was going to be providing, was the digitizer. Cordon, they entered into a teaming agreement to pursue this business. Cordon got the work, and after they got the work, they said to Schaefer, okay, please give us an assurance that you're going to perform. And Schaefer said, why don't you just issue an order, and that's your assurance? And Cordon says, hang on here, we're getting our ducks in a row. Why don't you just give us assurance, give us updated pricing, et cetera, et cetera. Schaefer said, no, you've made a promise under the teaming agreement that you're going to use us, so go. And Cordon ultimately, not feeling that Schaefer was cooperating, Cordon went and started buying, getting different quotes. Schaefer sued, saying, Cordon, you can't do that. We entered into a teaming agreement, and you promised that you were going to buy from us, and you have to. And the court ultimately said, no, sorry, Schaefer. The essential terms in your teaming agreement were too vague and indefinite to be enforced. You agreed to work together, but at the end of the day, you couldn't close the deal. You couldn't negotiate the final agreement. Your teaming agreement didn't specify a subcontract price. I'm not sure actually that it really could. I'm not sure that you're that far into it, but maybe there are circumstances. But the court focused on price there as one of the reasons why they couldn't ultimately take the next leap to forcing an award of a subcontract. There was no agreement on price. Schaefer was not contractually obligated to deliver the digitizer. Cordon reserved the right in its discretion to pursue a replacement product. There was no remedy spelled out for the breach. No method of determining damages. The court says, look, we agree that you guys agreed to work together. But as far as, was there a firm promise that Cordon must buy from you in the future? That was subject to negotiation. Your teaming agreement was an agreement to agree to something else in the future, and that's too vague and indefinite to be enforced here. So you promised to work together. You didn't work together well. Nothing that the courts can do here, and so they send them away. Now, a couple years later, there's an interesting case here, EG&G versus the Cube Corp. This was to provide M&O, management and operations services, for the NASA Wallops Island facility in Southeast Virginia. And the court here concluded that the teaming agreement between EG&G and Cube did impose an absolute duty to award a subcontract. Why? What's the difference here? Well, fundamentally, you had a different type of a teaming agreement. It had different terms and promises in it. EG&G had been the incumbent contractor there, and when it came up for a recompete, the government decided to do it as a business set-aside. So they found the Cube Corp. They said, Cube, would you like to team with us? We, EG&G, will be the small business, or excuse me, will be the large business subcontractor. We'll do 50% of the work. We're mindful of the limitations on subcontracting here, but we can give you intel. We know what this is working like here. And Cube says, yeah, that's a pretty good deal. And so EG&G drafted the teaming agreement. EG&G had a really good sense as to the work share. So they actually negotiated the future subcontract and included that as an exhibit to their teaming agreement. Not a bad deal if you could get it, especially if you're EG&G. Later on, when Cube predictably got the prime contract award, they were negotiating with NASA. Cube agreed to cap their rates. And then Cube went back to EG&G and said, we're going to need you to cap your rates. EG&G said, no, we've already reached our agreement. If you got the prime contract award, then you were going to go with us. Did I mention it's exclusive? There was an exclusive relationship here as well, which really limited whatever Cube's options were if they got the prime contract award. So ultimately, when EG&G wouldn't cap rates, Cube got upset. They started awarding work share to the contractor. EG&G sued Virginia court for contract, and ultimately the court came out and said, yeah, you're right, EG&G, you are guaranteed work here. The court, what was different on this from the digitizer case? There was an exclusive written teaming agreement, right, that made clear that there was will, shall, if, then. There was a lot of mandatory language in there, talks about what Cube would do if it got the contract award, then it would award a subcontract. The court didn't have to speculate as to what this subcontract looked like because, as I said, it was already attached as an exhibit. There were a few minor details to work out, but the court says those really were not central to the overall bargain here. We knew what the parties would do. We knew what the pricing would be. At the end of the day, the key difference was Cube capped their rates and was bothered that EG&G wouldn't. That was a breach from the prior agreement here, and so the court concluded that that teaming agreement, as written and as negotiated, very specifically, really in favor of EG&G, imposed an obligation on Cube to make the contract award. All right, now a few years later, after that, there's another Virginia case that kind of settled somewhere in the middle, but closer to the digitizer case. This is called CyberLock Consulting versus Information Experts. And this case involved two companies that would do background check services for the Office of Personnel Management. And what it is, they entered into one teaming agreement, and Information Experts was going to prime it. CyberLock was going to be the sub, and Information Experts got the award, and they awarded a subcontract to CyberLock. Perfect. Second opportunity came along. Same structure, probably very similar teaming agreement that they negotiated and signed. Information Experts is the prime. They're negotiating their subcontract and they can't close the deal. And so ultimately Information Experts has to walk away. And CyberLock says, you can't. There is an obligation here to give us that subcontract award. And they point to the EG&G NASA case. Well, the court here says, look, we get that you have those two different cases that are very fact specific, but at the end of the day, CyberLock, you're more like the digitizer case than like the EG&G case. What you have here is an unenforceable agreement to agree. The fact that you had project number one that worked and project number two doesn't necessarily mean that there was an obligation. It means you negotiated the solution under project one, but you couldn't close the deal on project two. There were still some, while yes, there were some specifics in it, specific work share allocations. There was some mandatory language of if then. There was also some mushier language that made it clear that there was still a subcontract to negotiate in the future. They tried to negotiate that subcontract, and at the end of the day, they couldn't reach agreement. That doesn't mean that Information Systems breached by walking away. It just meant that the two parties couldn't reach an agreement. But it didn't mean that CyberLock had Information Systems over a barrel the same way that EG&G did with Cube. So here in this, there was some mushier language indicating that the future subcontract was subject to negotiations, that the teaming agreement would terminate based on the failure of the parties to reach agreement, that the subcontract award was ultimately subject to the government's approval, without necessarily limitations based on Part 44.2, as we talked about earlier. So as a whole, the court says, look, we see some firm language here. We see some mushy language. We're going to read the contract as a whole and conclude that this is closer to the digitizer case than it is to the EG&G case. So Virginia choice of law generally favors prime contractors, and that it gives them, is more likely to conclude that a teaming agreement is an agreement to agree. But remember, you've got that EG&G case that stands for the proposition that if there are firm promises that are made, then those firm promises can be followed through on. What it means, the practical matter, is that your choice of law provision in your teaming agreement might matter. Virginia is very common because we have a lot of government contractors in the Northern Virginia area. But you know, other areas like Maryland is mostly like Virginia. Again, Maryland in the Washington, D.C. metropolitan area. California is a little bit of a mixed bag. Missouri, New York, Texas, these might be a little bit more favorable to subcontractors insofar as they might require additional good faith negotiations of that future subcontract. But none of these jurisdictions stand for the agreement that a loose teaming agreement saying we're going to work together, and if you get it, then I get the subcontract, and we can't ultimately close on that subcontract. None of them stand for the proposition that the sub is entitled to work. So the original question of is that I was asked with the fellow who took his glasses off, wow, is a teaming agreement enforceable? The answer is only insofar as there are promises made that are enforceable and that are not kept. Is it a guarantee of future work share? No, it is not. But does it mean that it might move you further along, and does it mean that you might negotiate that future subcontract as EG did? Perhaps. And if that's the case, then it is more likely that maybe your teaming agreement would be enforceable and get you that guaranteed work share. So what does that mean then? What are some things that we should possibly look at and consider as to whether to reinforce the enforceability of this? Exclusivity was critical in the case of the EG&G case because Cube didn't have any other options. So maybe an exclusive teaming agreement is going to be better to force enforcement of it. What are the obligations of the parties here? How are they spelled out? What are we promising to do? In the case of EG&G, very helpful that they essentially had a pre-negotiated subcontract. But other issues that the courts look at, what are the promises? What's the nature of the work, the scope of work, place of performance, contract schedule? If you want to make sure you've got a tighter teaming agreement, more like EG&G and less like the digitizer case, you want to make sure that you're taking some of these issues into consideration here. Or not. Like it's a teaming agreement. Maybe you don't want to define your requirements specifically in order to allow yourself maximum flexibility. As I said before, if you're the sub, a lot of times you want it, you want to lock it down, but maybe not always. As we had on that question before, or my client that did the telecommunication services over Antarctica, right? They realized I want to keep my options open, even though I'm the subcontractor. And it worked out well for them. So anyway, these are issues to consider when you are drafting and updating your teaming agreement to make sure that it's meeting your business objectives. All right, Zippera says, why would primes disallow subs from reviewing the proposal information that the sub contributed? They always redline this addition on the teaming agreement. I don't know that I have really encountered that. I guess to answer your question, Zipporah, the part of it for me is you probably have a prime that wants to keep control over everything. But I agree that feels a little silly that if the prime is limiting what the sub can do with information that the sub provided, that feels a little silly and inconsistent. Kim says, how can a teaming agreement specify a subcontract price when you haven't even negotiated the rates yet? That is a great question, and it's an existential question that these teaming agreement cases often face. Whenever they're saying it's an agreement to agree, they're saying you haven't negotiated price. To which my response is, how can I negotiate price? Maybe in the case of EG&G, they knew exactly what they were getting to because they were just coming off of performing that contract for the last 10 years. But I think that it's a point that the courts often point to justify why an agreement to agree fails as opposed to why it stands. But I agree that it's often, I don't know. I've never actually managed to come up with a perfect solution for that of how you come up with a subcontract price in your preliminary teaming agreement. Maybe if you've got all the intel, but I would say 98% of the time you do not. So Kelly says, back to the CTA issues, David, can you have an acquisition that intends both a set aside and unrestricted task order opportunities where you could have both set asides qualifying and large business CTA team member? I think possibly. on that. It would probably depend if it's the same task order, you'd probably have CLINs that are partially set aside. And I think in that respect, you would specify in your proposal who's going to be doing what on that. And again, we have a large business. They're technically a member of our CTA, but for purposes of that CLIN, they're going to be a subcontractor just to make sure that we're compliant. I think that's how you would probably frame that. All right, thank you. Great questions, everyone. I really appreciate them. Let me talk about data real quick here. Please make sure that you are protecting your data with your teaming partner. Commonly, what I see is teaming agreements have a provision in it that relate to data confidentiality. You and I agree to protect each other's proprietary information. The ultimate subcontract ultimately has provisions relating to data confidentiality. But don't wait to sign an NDA until you've got your teaming agreement in place. Meaning, commonly, I think what it is companies enter into an NDA when they start discussions, and then that evolves into a teaming agreement, which typically evolves into the subcontract relationship. So my recommendation to companies is you want to enter into some kind of protections for your proprietary information early and often. And the key on this, you can find templates online. They're not, NDAs are usually not very complicated. You want to make sure that you are labeling your information as confidential and that the other side in turn agrees to protect it as confidential. That's the key thing you get out of your NDA. And again, typically what I see is companies enter into an NDA when they're talking, and then they formalize a teaming agreement and they have some data protections in there. And often that kind of consistency will flow into the subcontract. But I think that's a good best practice. Make sure that you are labeling materials as proprietary, especially if you consider them proprietary. The risk is that it's proprietary, you don't tell the other side, and now it's been publicly disclosed and maybe they'll use it. If it's proprietary, I assume it's valuable. So let the other side know that and make sure you have NDAs in place. All right, I mentioned the small business concerns. If you are, teaming agreements are ideal for building relationships with small businesses. And this is specifically recognized in the FAR Companion. And again, I said before, it might be from the prime that has a small business subcontracting plan. A large business prime has a small business subcontracting plan, or it can be a small business prime that's trying to leverage past performance or experience from a large business subcontractor under a prime contract that's been set aside for small businesses. If you do this, though, the key thing you want to make sure, there's three key things that you want to keep in mind on this. One, you want to make sure that you are careful for affiliation. Affiliation essentially comes in and it considers that any companies that are under common control are going to be aggregated for purposes of size. So let's say I'm a small business and I have 5 employees, but ultimately I'm owned by Jeff Bezos. Guess what? I'm not small. Even though I only have 5 employees, even though I maybe only had $500,000 in revenue last year, right? Let's be honest, I'm owned by Jeff Bezos, right? So that question of affiliation commonly comes up in the question of who controls the entity. And you might have 2 companies that start off, you're large, the other is small, and they start off at arm's length, but in time they get a little too cozy, and functionally that large business controls the small business. You want to make sure that your relationships, your teaming agreements maintain an arm's length relationship such that that large business doesn't accidentally control the small and accidentally create affiliation. You also want to be aware of the ostensible subcontract rule. What this means is you have a small business small business prime contractor under a small business set aside and a large business subcontractor that is going to be doing the primary and vital portions of the work. The idea behind this is, yes, they're a subcontractor, but only ostensibly so. When it comes to who is gobbling up most of the work, it's the large business. And this is a small business set aside. So this is a common issue that comes up in size protests. And you want to make sure, small business prime contractor, that you are performing primary and vital portions of the work, and that you're not just merely a pass-through. It is a common protest ground, and companies commonly lose service contracts because they are deemed affiliated for that particular opportunity there, because the large business subcontractor is only ostensibly a sub. In truth, it feels like they're doing more of the prime contract work. The third issue here relates to the limitations on subcontracting. Limitations on subcontracting basically say for a small business set aside, the majority of the work needs to be performed by a small business or service disabled veteran owned or woman owned or hub zone or 8A or small disadvantaged business, whatever it's set aside for. The idea behind this is the government wants to make sure that those dollars that are set aside for these special interests actually reach those special interests, as opposed to you set up, say, an 8A company as a front and large businesses reach through and do the majority of the work. So there is a specific FAR clause relating to limitations on subcontracting, and generally speaking, the rule is that the small business needs to do at least 50% of the work, and it doesn't necessarily need to be exclusively one small business. It can be multiple small businesses. But small businesses would need to do at least 50% of the work, and then large businesses would do perform the balance. Let's see here. Boryana says, is there any harm to the prime contractor to list the NECs, the cage code, and or UEI of the small business team subcontractor in the teaming agreement? It says, this is asked in the context of including the teaming agreement as part of the prime's proposal when required in a solicitation. My answer is no, I don't think there's any harm in that. One of the keys on this, in order to, you want to make sure that you are identifying the relationship to the government customer, and to the extent you're identifying that specifically, then more's the better. So no, I don't see any harm in that kind of specific identification on that. All right. Last point here relating to exclusivity. The FAR specifically recognizes there are certain situations where the government will not recognize teaming agreements, and if they raise anti-competitive concerns, then they will say no on them. The National Reconnaissance Organization, this is the government's spy satellite agency, has a provision in its FAR supplement specifically saying we do not recognize exclusive teaming agreements, because they view them as anti-competitive, limiting, possibly driving up the price on this. In truth, a teaming agreement can be anti-competitive. If you have two companies that formerly would have been competing and they enter into a teaming agreement to cooperate, it's possible the government's only going to be getting one offer, which could indicate some kind of loss of advantage, increased price, maybe even collusion, although there are legitimate business reasons as to why two competitors might team together on this. But in that situation, the government may very well say, no, we're not going to recognize exclusive teaming agreements because it's limiting competition. The other issue that I mentioned is vertical integration. I gave the example earlier of my client that provided telecommunication services over Antarctica. They were the only company at the time that could provide these types of services. And so if somebody had signed them exclusively, that prime contractor might have walked away and said, guess who's getting the prime contract? So in that situation here, the government, again, may say, we're not going to recognize any exclusive teaming agreements. The subcontractor can still provide services through multiple vendors. We're going to get the business. My client got the business one way or the other, but it still allowed the competition to the at the prime contract level. There are advantages and disadvantages to this. You don't have to do exclusive. You don't have to do non-exclusive. One of the disadvantages, you could find yourself married to a loser, and I don't know, maybe their technical solution or their price is not getting you where it needs to be. One-way exclusivity, if you know that they are teaming also with some of your competitors, I don't know, maybe there's some risk of proprietary information bleed. So think through that. But maybe some of the advantages is you're getting the mutual commitment. In the case of EG&G, maybe you're getting a guaranteed subcontract award. So that can possibly work both ways. Last point on this, what should we do if things go bad? By their very nature, teaming agreements are a little preliminary. And so I like trying to limit liability on these things. I like to try to build in off-ramps on this. While we're chasing business, if it's clear it's not going to work out, I want the flexibility to break up and go date other people, right? So in some respects, I joke that maybe we treat this as a little bit of a prenuptial agreement, right? No judgment, just at the end of the day, what's the lowest risk, least likely to result in litigation that we can coming out of these teaming agreements. I don't like litigating teaming agreements because nobody entered into a teaming agreement saying, I can't wait to hire Dave Gallacher to litigate this. Nobody does. They're designed as preliminary business development, strategic relationships. And so anything I think that we can do to try to keep it managed and keep the risk and liability contained, more is the better. So I recommend that all teaming agreements be in writing, that they be tailored for your specific choices, your business objectives. Make sure that they have some kind of a termination provision in it. And I see sometimes fault versus no fault, termination for convenience versus default termination. I don't really care on that. I just want to know that if my teaming agreement isn't going right, I want to be able to get out without judgment as to who's at fault. If you go bankrupt, I just want to get out. If you can't perform, I just want to get out. So I like the idea of building in some of these off-ramps. I mentioned limitations on liability, disputes provisions. Again, I like the idea of having some kind of escalation I commonly see in these teaming agreements. We're going to send this up through the VPs and then ultimately possibly arbitration if appropriate. So anyway. So those are 10 questions that I commonly get. Let me jump in and we'll do the quiz recap. So Joshua, if I could get this queued up here. Question number 1. I've got a few questions as well here that I'll come to at the end, but I want to get through these first, make sure that we're on time. Question number 1. Which of the following is listed in the FAR Companion as a reason that the government should recognize a contractor teaming arrangement? Is it A, the companies complement each other's capabilities? B, the companies offer the best combination of performance, cost, and delivery? C, the companies are encouraging small business participation? Or is it D, all of the above? What do you guys think on that? Which of those answers? All right, I'm going to give you a couple more seconds to chime in. And all right, Joshua, why don't you close that out? You guys are... Well, technically, everybody's correct. The best answer here is D, all of the above. The first 2 choices are specifically called out as reasons, but it also, one of the things that's been added to the FAR Companion is a recognition of the advantage that teaming agreements provide in these small business scenarios. So there you go. Question number 2, Joshua Lee. Which of the following are listed in the FAR Companion as government limitations on a teaming agreement? Is it A, antitrust concerns, B, the government approval, consent to subcontract under 44.2, competition and subcontracting, responsibility determinations, or E, all of the above? I had this on a slide that listed it. Let's see what you guys think. We'll give it a couple seconds more. Please chime in. Let me know what you think. Most of you are saying E, and you guys are correct. E is the correct answer. FAR 9.604 specifically noted, and that language has now been moved to the FAR Companion, that the government reserves the right to address these issues and others, notwithstanding the terms of a specific teaming agreement that you and I might have negotiated. Next, true or false, signing a teaming agreement guarantees a company future business if the team is eventually awarded a contract by the government. Is that true, false, or the cheeky answer, I don't understand the question? All right, I'm getting a couple trues. Well, Joshua, let's close that out. The answer is false. A teaming agreement is not usually a guarantee that a company will receive future work. On rare occasions, maybe, like we saw in the EG&G case. But usually, most courts interpret a teaming agreement as an agreement to agree, subject to future negotiations. Question number 4. What is one of the key differences between a standard teaming agreement and a CTA? Is it A, you have to use a specific federal form? Is it B, how the parties are paid? C, all of the team members must hold a GSA schedule contract? Or D, none of the above? And the answer is C, GSA schedule contract. Most of you, it looks like, got this. All parties to a CTA must hold their own GSA schedule contract. But again, you could have somebody like subcontractor Dave who doesn't have a GSA schedule contract, that's part of the little t team, but not part of the capital T CTA. Last question here is true or false? Federal law and prime contract requirements prohibit prospective subcontractor teaming partners from altering the terms of a proposed teaming agreement. Is that A, true, B, false, or C, Dave, I just sign whatever they give me? Put another way, can you negotiate your teaming agreement? True or false? You guys are saying false. That's exactly correct. These are always subject to negotiation. And there you go. We're at time. Joshua, do you have any last words that you have? Here's my contact information. I want to get to the other questions, so if you want to stick around for just a minute or two more, I'll get to those. But Joshua, I want you to see if there's anything else that you want to talk about.
I will put that rating poll for those who are hopping out. We'd love to know how we did today. Our feedback is appreciated. Make sure you guys hang on for any extra questions. And again, if you're seeking your certificate, log into the PCI website and you should see that a quiz for your certificate for this class. And with that, I will hand it back to David.
Okay, perfect. I'm seeing some hand clapping and hearts, and thank you so much, guys. I appreciate it, especially through the technical problems. Really embarrassed about that. I've got, if you have something you want to send me, feel free to do it. If you have something you want to type into the questions, Cassandra had one question here regarding the ostensible subcontractor rule. She says, is there a span of time the prime small business needs to be doing more of the contracted work? The answer is it's specified in the clause. It might be measured over the term of a particular task order or over a 1-year period, or it might be measured over the whole 5-year period. Typically, that is spelled out in the 52-219-14 clause, as it's spelled out there. She says, for example, if a small business wins a task order that was previously done as a large business incumbent, and the small business subcontracted the incumbent on the initial on-ramping of the contract, and then the idea was to balance that out later on, could that work? And the answer is, in theory, yes. It will really depend on how the contract clause as included in your contract spells out that measuring period. I commonly see that it's measured over 5 years, and in that situation, you would be able to have the chance to make that up. Even though in the first year, it might be 80% by the large business, 20% by the sub, that could even out. So by the end of it, 20% by the small. At the end of it, that could invert. So you have the small business prime doing the majority of the work, just to make sure that you're meeting that requirement. So great question, Cassandra. Thank you. Tyler says, I didn't hear any passwords. We didn't have any passwords, Tyler. All you had to do was make sure you're interacting with those polls and you're in a good place. Let's see here. Anything else? I think we're in a good place here. I'll stick around for half a moment more. I've already gone 3 minutes over, which is obnoxious of me, but I blame it on technology. Joshua, anything else?
Nothing else on my end. I do wish everyone a wonderful afternoon. Thank you so much for joining us and sending your wonderful questions. You are more than welcome to send any other questions you have. We're more than happy to follow up. Make sure you guys check out the PCI website for our upcoming sessions. We'd love to have you all again. With that, I wish you all a wonderful afternoon. Thank you, David.
Thank you, everyone. I appreciate it. Happy spring. Good luck out there. It's a jungle out there, but you can do it. You can do it. I believe in you. Thanks, everyone. Have a good day.